Thank you very much for joining this webinar today. And sorry that you had to put up with oh my God, I don't know how to open up a video drama. We fixed it. So this is a webinar which we're super happy to host today with Jay Gagan from Allen & Overy in the United States, addressing the issue of injunctions under the ITC. I saw the PowerPoint presentation in advance and was profoundly impressed by the quality of thinking. I hope you'll find it as exciting and interesting as I did. So just by background, Oxfirst is an economic consultancy. We were launched 12 years ago out of Oxford University. We are based in Oxford and in London, and we have a strong interest in the economics of IP and competition law, in standard essential patents and FRAND, the value of FRAND licensing rates, and the value of injunctions, and injunctions both as a legal remedy and a political football. Jay is a partner with Allen & Overy, and I think can hardly think of anyone more qualified than Jay to talk about this. Jay, I think, should I bring up your PowerPoint presentation, or are you?
Yes, please. That would be excellent. Thank you, Roya. So while you're doing that, I'll introduce myself. So my name is Jay Gagan. I'm a partner here in the IP practice of Allen & Overy in Washington, D.C. It's a pleasure to be here and a pleasure to have the opportunity to address such a diverse group from around the world. My colleague Noah Brumfield was going to speak with you as well today, but he was currently called away to perform one of only two duties we have as U.S. citizens. He's serving on a jury. We'll have a quiz at the end of the webinar as to what the other duty we have as U.S. citizens, but Noah sends his regards. So today I'm going to talk about the current and uncertain climate in the United States as it relates to the enforcement of standard essential patents, and in particular where we stand with respect to the ability of owners of standard essential patents who have made voluntary commitments to license on fair, reasonable, and non-discriminatory terms to obtain injunctive relief. So if we go to the agenda, the next slide. So very briefly, what we'll discuss is how U.S. agencies view standard essential patents, the risks and benefits of standard essential patents, the framework for obtaining injunctions in U.S. patent cases, how specifically the International Trade Commission views and analyzes these issues in the context of issuing its remedies, and then the implications under U.S. competition law. So please do ask questions as we proceed. We'll do our best to either answer those as we go or at the end. So first of all, part of the complexity around these issues in the United States is that there are a number of different U.S. agencies that have an interest and who have weighed in on these issues over the course of the last 10 years. In particular, we have the United States Department of Justice, or DOJ, from a criminal enforcement angle. We have the Federal Trade Commission, the FTC, from a civil enforcement and consumer protection angle. We have the National Institute for Standards and Technology, of course, from the perspective of the standard setting bodies. We have the U.S. Patent and Trademark Office as well. But despite these different and sometimes, I think, competing interests, all the U.S. agencies share the same recognition of the importance of standards in the U.S. economy. The agencies recognize that these industry-developed technological standards can be vital to things like health and safety. Standards can facilitate interoperability, which is undeniably a benefit to consumers and competition. They can foster innovation by encouraging market participants to invest in building technologies on top of those standards. And voluntary standards avoid inefficiencies in technology investments. And so all these agencies point to standards as foundational to the US economy, foundational to the development of modern technologies like mobile devices. And really, you only need to look at the Biden administration's announcement just last week as to new electric vehicle standards to see how the administration views the importance of these standards in the US economy. Go to the next slide. However, there's always a however. All these U.S. agencies, when they've weighed in on these issues, have also recognized that standards and standard essential patents can create risks to competition and may encourage anti-competitive behaviors and impacts. Fundamentally, once a standard incorporates a patented technology and that standard then gets locked in, it can become prohibitively expensive for someone to switch to a different technology or avoid use of the patent at all, which provides the owner of the patent increased market power. Theoretically, this would provide the owner of a standard essential patent the ability to demand higher than reasonable licensing rates, which could lead downstream to higher consumer prices, which of course is something that, as a matter of US antitrust law, raises concerns for regulatory agencies such as the Federal Trade Commission. This is also why agencies recognize the importance of standard setting bodies in requiring voluntary licensing commitments, because it's really these FRAND promises in theory that could mitigate the potential for anti-competitive behaviors that the agencies have expressed concern about. And it's also why you've seen agencies encourage standard setting organizations to require FRAND commitments as part of their patent policies. Next slide. Yeah. So it's really this tension that we're here to talk about today, because what we end up with is a really complex environment and an enforcement gray area that we found ourselves in over the last 10 years or so, because there's a conflict between, on the one hand, the benefits of standards and the rights that are given to any patent holder, including holders of standard essential patents, to exclude others from practicing a patented invention without a license. And on the other hand, the agency's desire to limit the abuse of market power and rein in sort of bad faith or anti-competitive activities. And this all comes to a head with respect to the availability of injunctions. Why? Well, the injunction could allow the holder of a standard essential patent to engage in holdup, or in other words, to extract artificially high royalties under the threat of that injunction. And artificially high license rates, as we said, could lead to artificially high prices, which is fundamentally harmful to consumers and competition. On the other hand, if an injunction is never available to the holder of a standard essential patent, then a bad faith company or implementer can simply refuse to take a license at all and force patent holders to engage in expensive litigation in a number of different jurisdictions and venues and try to pay nothing at all for usage of the patented technology. So we see a number of different factors that the agencies have articulated over the years that could lead them to a conclusion that an injunction for infringement of a standard essential patent is either warranted in certain circumstances, or in other circumstances, competitively harmful, or maybe potentially even illegal. And what's interesting that when we look at this is that in almost all cases, it comes down to an assessment of the conduct of the parties during negotiations, the conduct of the parties in terms of proposing certain license rates. And it's really this conduct of the parties before a case was filed that we see the agencies particularly concerned with. So with that background, let's talk a little bit about the framework for issuing injunctions in the United States. If we could go to the next slide. Perfect. So first, as folks would be aware, in US District Court, there are a number of different remedies available for patent infringement, depending on the facts and circumstances of each particular case. They include royalties, lost profits in certain circumstances, preliminary and permanent injunctions, enhanced damages, and attorney's fees in certain egregious situations. Of course, if the parties are willing and request the court to do so, then US courts also may determine and declare a FRAND license rate, both as to the US or globally. The point is, in contrast to some other jurisdictions, and in particular some civil law jurisdictions, injunctions are simply one of the available remedies that holders of standard essential patents have in US District Court. Go to the next slide. So let's talk about the ITC. So the International Trade Commission is a unique agency. It's what we call quasi-judicial. And so what the International Trade Commission does, among other things, is that they hear claims under Section 337 of US law. Section 337 makes unlawful unfair competition in importation. And that includes the importation and sale of goods that infringe US patents. Now, what makes the ITC so relevant to this issue of standard essential patents is that the ITC only issues injunctive relief, which makes the ITC closer in many respects to a civil law jurisdiction such as Germany or even China. And the most common remedies for infringement of US patents in the ITC are limited exclusion orders, which block the importation of infringing products at the border. These are orders that are enforced by US Customs. And cease and desist orders, which block the importation and sale of imported products from US inventory. And so put those together, and what you get is a nationwide injunction. Now, this is in part why US agencies, competition agencies, have focused so much on the ITC in their consideration of what are the potential anti-competitive impacts of standard essential patent holders seeking injunctions for patents subject to FRAND licensing commitments. The ITC affords patent holders, including, as we'll discuss, holders of standard essential patents, the opportunity to obtain a nationwide injunction that prohibits the sale of infringing products in the world's largest economy. The ITC gives patent holders tremendous leverage in licensing negotiations, not just in the United States, but worldwide. We go to the next slide. So let's just pause a minute and think about here, what are the analyses that these different venues here in the US consider when they're considering whether to issue an injunction. This is the same for standard essential patents as it is for all other patents. District courts follow the standard clarified by the Supreme Court in the eBay case some years ago. One aspect of that analysis is the public interest, but that's not the only factor in the analysis. And importantly, we can see that one of the factors in the analysis to obtain an injunction in district court is that there are inadequate remedies available at law to compensate for the injury. Almost by definition, this would exclude declared standard essential patents subject to a voluntary licensing commitment because holders of SEPs and standard essential patents can receive FRAND licensing rates. And so they almost by definition would have a remedy available at law to compensate them for that injury. And for that reason, almost universally, US courts have recognized in the last 10 years that injunctions for infringement of standard essential patents are practically not available, or at least extremely difficult to obtain. The ITC doesn't follow the eBay case. The ITC follows its own law, Section 337, which sets forth these 4 public interest considerations that the ITC must assess before issuing the injunction. But it's important to see that the ITC is not constrained by this same analysis that US courts apply. So the other important thing to consider about Section 337 and US law is that you can see it requires the ITC to issue an injunction unless the public interest factors weigh in favor of permitting the continued importation and sale of the infringing products. So you can see that the law itself says the ITC shall issue a remedy. And you'll see here that these factors do consider health and safety, competitive impacts in the market, but the analysis is set up in such a way as to favor the issuance of a remedy in almost all circumstances if infringement is shown. And it's for this reason that the ITC sees its role as weighted heavily in favor of protecting US IP rights. And it has only refused to issue a remedy based on consideration of these public interest factors a handful of times in 40 years. So it's very rare. If we could go to the next slide. And so on the next slide, what we've done is pulled together some numbers.
We have a question.
Yes. Oh, sorry.
Sorry, I was on mute. I didn't realize you couldn't hear me. Kevin Curran asks, will ITC grant counsel fees to a successful petitioner against the respondent? If so, must an award be no more than $100,000?
The short answer is generally no. To get a remedy such as fees in the ITC, you must demonstrate that there was some sort of conduct in which a party was ignoring an order, or akin to what we refer to as Rule 11 in U.S. district courts, that a party essentially engaged in bad faith litigation and filed a complaint for some reason other than enforcing its IP rights. And so generally, no, fees are not available to those who prevail in the ITC. So here on this slide, what we've done is actually pulled the numbers. This is not an exact science, but we went into and tried to pull some data. This is for all cases, not just cases involving standard essential patents. You can see the decreasing numbers of injunctions for all cases in US District Court over the course of the last almost 15 years. And this is out of almost 60,000 patent cases terminated in US District Courts since 2009. But out of less than 700 ITC cases, you can see that the ITC has remained relatively steady and almost perhaps a little bit of an increase as the number of cases continue to increase in the ITC. So the takeaway here is that injunctions are the very rare exception in US courts. As best I can tell, almost never sought at this point in cases brought for infringement of standard essential patents, particularly since cases such as Microsoft versus Motorola, now almost probably 10 years old at this point, in which a jury found that Motorola's efforts to seek injunctions in US and in Germany violated Motorola's RAND commitments and constituted a breach of contract, which justified damages and an award of attorney's fees. So the ITC is really where a lot of these issues come to a head in terms of the interest of competition law authorities and the assertion of standard essential patents. Go to the next slide. So let's talk specifically about the ITC. And as I said, the ITC is really the interesting case study for the current status of the enforcement of standard essential patents in the US. So the ITC is very clear that it maintains the authority and the jurisdiction to consider infringement of all patents. And it has never declined to issue a remedy on the basis that the patent asserted was a standard essential patent or subject to a FRAND licensing commitment. And in fact, you can see, I've provided some examples here, the ITC and ITC judges repeatedly have held that the ITC may issue injunctions for infringement of standard essential patents. The underlying law, Section 337, makes no distinction between standard essential patents and other patents. Filing a complaint in the ITC does not necessarily, or in and of itself, violate a voluntary commitment of a party to license a standard essential patent on FRAND terms. And a FRAND undertaking does not necessarily per se preclude the ITC from issuing an injunction in the US. And they even have stressed in some recent cases too, that implementers don't have a safe haven in the ITC today and may be subject to an injunction. So that's on the one hand. We could go to the next slide. I think partly for that reason, we have, and you will continue to see, complaints filed in the International Trade Commission based on infringement of standard essential patents, notwithstanding past examples such as the Microsoft Motorola dispute that I referenced. This is not by any means an exhaustive list. This is just some notable cases that we've had in the ITC based on infringement of standard essential patents. Now, as I said, the ITC very clearly maintains its authority and jurisdiction to consider infringement of standard essential patents. But on the other hand, to the best of our knowledge, the ITC has never actually issued an injunction that then went into force based on infringement of a declared standard essential patent subject to a voluntary FRAND licensing commitment. The only of these cases in which the ITC determined to issue an injunction was the Samsung versus Apple case. And that is the famous case in which the Obama administration determined to overrule the ITC and rejected the exclusion order before it went into force. Now, it's a very interesting discussion to have, and we can speculate as to why the ITC appears unwilling or perhaps hesitant to issue exclusion orders in these cases, or whether there's any pattern here at all, and it's just as it's just based on the facts and circumstances of each particular case. But I do want to reference that U.S. competition authorities do continue to express concerns, not just about the issuance of an injunction based on a FRAND-encumbered standard essential patent, but even the filing of the complaint itself in the ITC. So we'll talk in a minute about the Federal Trade Commission, but the two commissioners of the Federal Trade Commission last year recognize that the threat of an ITC injunction, even if an injunction is unlikely to issue, as we see in these cases, can lead to the anti-competitive risks that the agencies are concerned about, and that we talked about before, because it's the risk of that injunction that means that the holder of the standard essential patent can potentially leverage that threat, that risk, to extract supra-FRAND or more than reasonable license rates. So through the lens of the Federal Trade Commission, perhaps the holders of standard essential patents who filed these complaints were not necessarily concerned in the end with obtaining the injunction itself. Through the lens of the FTC, perhaps the complaint itself and the threat of the injunction was the goal here.
Okay, if I may add here, I published a research paper with Oxford University Press in 2018, where we expressed exactly this dilemma in economic terms through a game theoretical model, where we spoke about licensing in the shadow of the law, and where we said it doesn't need to happen. It's enough if it happens in the mind of the people. And there's already prior research which comes from the 1970s about the same dilemma in the context of divorce law, that people calculate about the potential risk that could happen in such and such circumstance, even if it's never going to happen. And our conclusion was it can go both ways. It is either the risk of an injunction or either the risk of not having any chance to enforce one's patent at all. And my personal conclusion was the golden middle way is the solution. But I'm extremely pleased to hear that there has been policy reflection eventually on this, because we exactly said that it doesn't matter. It is in the mind of people. People are calculating with respect what could possibly happen, and we have the model published on that. So
Yeah.
very happy to hear you say that.
Yeah, thank you. That's interesting. And you'll see if folks are interested in pursuing that, we'll talk about the statement of the Federal Trade Commission commissioners in this case that I reference here on this slide, the Phillips case recently, in which they expressed that concern exactly that you mentioned, Roya, as well. So so let's just talk briefly, we can get through this, about the public interest analysis itself on the next slide. The public interest analysis is where the ITC may consider all of these factors in determining whether to issue an injunction or whether to tailor that injunction in some way. The most important thing to understand about the public interest analysis is that the ITC doesn't see itself as addressing those policy or trade policy or competition law policy questions, Roya, that you were just referencing. The ITC sees this analysis as limited to the 4 statutory factors that we talked about earlier. And in particular, they see the analysis as whether the ITC should continue to allow the importation and sale of infringing products, notwithstanding the existence of a US patent right that's being infringed by those products. The most important factor, it's almost a gating analysis that the ITC looks at, is whether there are non-infringing or US manufactured alternative products that are available to meet the demand for the infringing product that will be excluded, subject to the injunction. If there are non-infringing alternatives or US manufactured alternatives, then from the ITC's perspective, there's almost zero chance that the public interest would weigh in favor of not issuing a remedy, because the injunction is not going to meaningfully impact the market or competition. US consumers can just simply switch to those other products. Now, if an exclusion order will materially impact the US market, then the ITC is more likely to consider the substance of these arguments that an injunction will negatively impact the public interest. In the circumstances of a standard essential patent, the ITC has considered the underlying circumstances and conduct of the parties. For example, in this recent Philips case that I mentioned involving 3G and 4G wireless standard, the ITC judge assessed at length the relevant language of the ETSI standard, the obligations of the parties under the standard patent policy, and then the conduct of the parties in the licensing negotiations. Although the judge in that case ultimately based his decision to recommend a delay in the issuance of the injunction on other factors, not on the conduct of the parties, it's clear that they will view this question of the parties' FRAND obligations and the parties' conduct and the competitive impacts of issuing an injunction based on standard essential patents as a valid part of the public interest analysis. We just haven't seen a case come up yet in which the ITC has expressly declined to issue a remedy due to the existence of a voluntary licensing commitment on FRAND terms. The ITC simply always, in those cases, finds other reasons not to issue a remedy, whether it's on the merits or whether it's on some other basis. But the ITC judges, again, have always emphasized the lack of a public interest impact from the fact that the patent is a standard essential patent on its own. Okay. So let's talk, if we could go to the next slide. Now that we've discussed sort of the underlying issues and the availability of injunctions, let's talk about where we are right now in terms of how US agencies view this issue and how they view the availability of the ITC and injunctions for infringement of standard essential patents. It's a little confusing. So the backstory is that in 2013, under the Obama administration, 3 of the relevant agencies, the Department of Justice, the Patent and Trademark Office, and NIST, the National Institute for Standards and Technology, issued a joint policy statement expressing those agencies' concern about the issuance of an injunction for infringement of a standard essential patent subject to a FRAND commitment. And they stated specifically there that injunctions in those circumstances may harm competition and consumers by encouraging opportunistic and anti-competitive behaviors. This was issued sort of around the time that we began to see a lot of worldwide disputes, and this issue became highly relevant in terms of those disputes between Microsoft and Motorola, the acquisition of Motorola mobility patents by Google. This was around the time of the Apple-Samsung disputes and the investigation of Samsung by the Department of Justice. So there was a lot of activity at that time by US competition agencies. So then in 2019, like many policies, the Trump administration revisited that policy, and those same agencies withdrew the 2013 statement. They released a policy that expressed what might be considered an opposite viewpoint, which was that all appropriate remedies should be available to holders of standard essential patents, including injunctions, and that these FRAND disputes, these were essentially not a matter for US competition law. That was the policy of the Trump administration as expressed in 2019. Late 2021, in the Biden administration, like many policies, the pendulum seemingly swung again with the release of this draft policy statement in December 2021, about a year ago. And those same agencies, again, sought to withdraw the 2019 policy and issued a draft that would, in large part, return to the fundamentals of the 2013 statement. The agencies stated that monetary remedies are usually adequate to fully compensate a holder of a standard essential patent for infringement. They encourage parties to conduct negotiations in good faith. They encouraged courts to consider all the underlying facts before issuing an injunction for infringement of standard essential patents, and they generally sought to discourage injunctions. Then, in June of 2022, just last year, the agencies, somewhat surprisingly, withdrew that draft policy entirely. And they stated that they would review the conduct of the parties in these situations on a case-by-case basis. So where we are right now is that there is no policy from these agencies, from the DOJ, from the PTO, or from NIST at all. It is, we are in a case-by-case situation according to the DOJ. So if we go to the next slide. And it's really, so this lack of a coherent policy from the administration, despite these attempts at cooperation and coordination amongst the various agencies, has led, I think, just over the course of the last 8 to 10 months to have some agencies attempt to pursue different policy priorities. So the DOJ, as we said, expressed its belief that it would consider these circumstances on a case-by-case basis. The new director of the Patent and Trademark Office, Kathy Vidal, she announced several months ago her support of an effort by the World Intellectual Property Organization to encourage arbitration and mediation as a way to end global disputes over standard essential patents, which I think in some circumstances would obviate the need for country-by-country litigation and injunctive relief. So at least on the part of the PTO and its new director, there seems to be some support for figuring out a new system for analyzing these disputes. But the FTC is generally not part of these conversations. And the FTC continues to chart its own path. Could go to the next slide. So as I mentioned, there was this Phillips dispute in the ITC last year. And that case went to a merits decision. And it went to a merits decision, and the ITC requested input on the public interest factors. And there was a lot of interest in that case specifically because it seemed at a certain point like the issue was really teed up for the commission to determine whether it would be appropriate to issue injunctions, issue exclusion orders based on infringement of a standard essential patent subject to a voluntary friend licensing commitment. And you even had in that case the respondent indicating that it was willing to take whatever friend license determination the district court came to, and that there was no need for the ITC case at all. So in response to that request from the ITC, 2 commissioners, not the FTC itself, but only 2 commissioners, submitted a public interest statement setting forth their increasing concern, so their words, that holders of standard essential patents are seeking exclusion orders. And it's that seeking of exclusion orders that they were doing for the purpose of gaining leverage in negotiations. And they even went a step further, you can see here, and set forth their view, again, not the FTC's view, but their view of these 2 commissioners, that an ITC exclusion order based on infringement of a standard essential patent subject to a friend licensing commitment has the potential to cause substantial harm to US competition, consumers, and innovation. So even though this was a statement of only these 2 commissioners and the FTC took no position on the facts of the case itself, we think that holders of standard essential patents should absolutely take notice because it raises the possibility that the FTC remains willing to explore potential antitrust claims or other claims based on theories of competitive harm as it relates to the assertion of friend encumbered standard essential patents in the ITC. And one way to look at this statement is an effort by the Federal Trade Commission to put a flag in the ground and maintain the flexibility to address the conduct of parties on a case-by-case basis after some recent defeats that the FTC has had in US courts, including in the Qualcomm case. But this does not mean that the FTC would necessarily be successful in a case like this because US courts continue to express, say, skepticism or even outright disagreement regarding the FTC's theory that standard essential patent holders have some sort of antitrust duty either to license those patents to their competitors or that a breach of a friend licensing commitment can give rise to antitrust liability. Of course, the well-known famous FTC Qualcomm case. In that case, the Ninth Circuit Court of Appeals expressly rejected the FTC's theory and found that Qualcomm's conduct in licensing did not give rise or form the basis of antitrust liability, and that the remedy for breaches of FRAND licensing commitments was under contract law or tort law, not antitrust or competition law. Similarly, we have the Continental Automotive case in the Fifth Circuit, reached a, we could say, somewhat similar holding in that the court specifically held that it is not anti-competitive for the holder of a standard essential patent to violate its FRAND obligations. So even though we have the FTC commissioners telling the ITC and publicly expressing their continued interest in potential claims, the trend in the United States continues towards this skepticism that seeking injunctions for infringement of standard essential patents subject to FRAND licensing commitments can give rise to an antitrust claim. The FTC is running counter to what we see as the overall trend. So consistent with this trend, certain holders of standard essential patents also may feel somewhat encouraged recently to seek injunctions in the US and to go to the ITC, because we have the IEEE announcing that it changed its policy just a few months ago, that it would revise its policy to clarify that seeking injunctions would not necessarily constitute a violation of the patent holder's FRAND commitments. Again, this reflects the view and this trend that we're seeing, including from the Department of Justice and the ITC, that standard essential patents should have injunctive relief available to them as a potential remedy for infringement, particularly in the event that an implementer is engaging in holdout or refusing to engage in good faith negotiations. So if we could go to the next slide. So does this mean that the FTC is does this mean that a claim is always off the table? We think no, because there are going back in time a number of possible approaches that the FTC or even the DOJ might take in tackling sort of bad faith conduct or holdup under antitrust law. And there are some older examples of this. The FTC can bring traditional antitrust claims, but also consumer protection and fraud cases. And a case kind of blending those different types of cases was this older FTC complaint and litigation under the FTC Act against Unical. And in that case, the FTC brought a claim that Unical had failed to disclose certain patents that would have covered a California state standard relating to gasoline. And then when Unical was acquired, the FTC raised that complaint and those concerns in the context of its review of the merger. We've also seen the FTC raise similar issues with respect to standard essential patents in the context of other mergers, the Google Motorola mobility transaction being one. And so while the FTC may have an uphill battle in the courts to bring traditional antitrust claims, there's still the potential that we see that these issues could get raised in other contexts. In fact, if you read the statement from the FTC commissioners in the Philips ITC case, you can see them reference the Google Motorola example on page 1. And the FTC commissioners also reference the various laws that the FTC can leverage in addressing bad faith conduct in licensing negotiations. Okay. So with that, we'll pause here. Where does this leave us? What are the considerations that parties should consider in connection specifically with ITC investigations based on infringement of standard essential patents? Well, we think first, it is still relevant what the specific commitment is that holders of standard essential patents have made to license patents on FRAND terms, even if that is only raised as a breach of contract type defense. It's also relevant whether the parties engaged in good faith pre-lawsuit negotiations as to a potential license consistent with those FRAND commitments. As we discussed, the ITC will consider those issues in the context of a public interest analysis, particularly if there's a potentially serious market impact. And we have the FTC sort of maintaining its ability to consider and bring an investigation based if they see bad faith conduct. Well, we think second, in view of the FTC's current position, it is relevant to consider whether seeking an injunction in the ITC will impact some key strategic market, some key strategic technology priority of the administration. 5G being an example. Because if these issues touch a key strategic technology or a key strategic interest of the administration, that would increase the chances of the ITC or other agencies such as the FTC finding a public interest impact and looking further into what the market might look like in terms of competition and in terms of potential market power. So third, we also think that parties should consider the litigation strategy. For example, if respondents to an ITC complaint do aggressively challenge the public interest in cases involving standard essential patents, if they do generate interest from third parties and Congress in these issues, if they do aggressively seek a determination of FRAND licensing rates from district courts before the ITC case proceeds to a final determination, the history of these cases, as we saw, suggests that those parties, those respondents, have a very good chance of winning on the merits and avoiding an injunction. Now, if that's the case, if parties aggressively raise these issues to the ITC in the context of these litigations, then perhaps holders of standard essential patents might consider the cost-benefit analysis of bringing a case in the ITC, the cost-benefit analysis of engaging in this type of litigation, spending the resources on it, given the historically low percentage of obtaining an exclusion order in those cases. So we'll leave it there. Happy to take questions. And it was funny because we framed this webinar as a question at the beginning. Are injunctions within reach? I'm not sure that we have an answer other than maybe. And perhaps we're in a position now, as compared to a year ago, where injunctions are increasingly available for holders of standard essential patents.
Thank you very much for this excellent overview. It's a mess, Jay. That's what I take from this. We have an opinion, we don't have an opinion as government, then we have another opinion, we change the opinion, now nobody really knows. It's the United States, as you said, one of the most important markets in the world. How long is that going to go on? I mean, this isn't like Luxembourg. This brings me back to what I thought in the outset, a legal remedy and a political football.
Yeah, it's a mess in terms of us having some sort of clarity from the administration on what the policy is. And it leads to uncertainty. But I think that uncertainty would, in my own view, probably tend to benefit holders of standard essential patents that are facing implementers that are unwilling to negotiate. So whereas before, I think there was an increased risk that you could gain the attention of US competition law authorities by seeking injunctions, not only in the US, but in Germany and in other venues. I think overall, the trend we're seeing is towards more recognition that holders of standard essential patents can leverage injunction as a tool, and they can increasingly not be concerned that there's going to draw the attention of competition law authorities.
Any questions from the audience? Comments, observations? You saw our audience lasted with us bravely since we went 20 minutes over time. That's a big sign that they liked it as much as I did, Jay. I think this was a really interesting insight and a very helpful overview. I'm really grateful for the work you put into this elaborated presentation.
Yeah, thank you very much. If I could make just one more, I said at the beginning,
Yeah.
what are the two things that US citizens must do? Our only two things we must do: serve on a jury, which my colleague Noah is doing right now, and pay taxes. I can't say whether Noah is doing that, but he's certainly performing one of his two obligations today. So thank you very much for the opportunity.
Great. No, thank you very much. Also, I must still say, because we still have a bunch of people on the call, the 8th IP and Competition Forum is coming up. Ta-ta. Please do join us. We'll run it online. It's in Brussels on June 20 and 21. That's Tuesday and Wednesday. we'll discuss a lot of the topics Jay touched upon today, as well as some European topics such as the Unified Patent Court and its implication for litigation strategy, and also the European perspective on injunctions in front contexts and other contexts. All of that being said, I really appreciated that very, very elaborate talk. If anyone is interested in getting involved in one way or another, please reach out to us, info@oxfirst.com. Otherwise, to Jay or Dora directly.
Yeah, thank you. We will provide the slides in response to a couple of different comments, and very interesting question. Just the very last question before we sign off. Do you think the Apple Watch will be excluded if no license is taken?
Oh, there's 6 questions. Oh my God. Oh, okay.
Yeah, I can very quickly answer. Well, I think the last one, I think it's clear that they have now exhausted the statutory obligations that they have to, or the statutory available remedies that they have to review the exclusion order. So it's gone through the review of the president. They have declined to veto the exclusion order. Now, helpfully for Apple, there was a stay issued in enforcement of the exclusion order in favor of proceedings that are ongoing at the Patent Office. And so I don't think there will be an exclusion order applicable to the Apple Watch until we have a decision from the Patent and Trademark Office on the validity of the patent. But as it relates to the ITC, Apple has exhausted its remedies.
Do you want to take any of these other questions, or are we good? Whatever it's up to you. I apologize. I really need to wear my glasses more consistently. I keep telling myself I just need them to read, and then I see 1 or 7. It looks the same. I don't see it anymore. Age.
Yeah, we have very interesting specific antitrust question, which my colleague Noah would be fascinated to answer. I think the short answer is yes. A holder of a standard essential patent has the basic right to seek an injunction, because if not, and you'll see that the DOJ and the FTC very carefully recognizing this point, if not, we would have a fundamental disconnect between patent law and antitrust law, because it is a fundamental principle of US patent law that a holder of a patent has the ability to exclude someone from practicing that patent without a license. So it's that really core fundamental aspect of patent law that gives holders of standard essential patents the basic right to seek an injunction in certain circumstances.
Well, I think we covered it.
Yeah.
Fine. So we'll make the slides then available now that we know we can. We'll also eventually get the webinar up on YouTube. Our webinars still have no chance in comparison to the webinars of some pop stars, but we'll get there eventually. Thank you very, very much for joining today. Have a lovely day.
Thank you so much.
Bye-bye.
Bye.